Welcome to Philosophy Online Lecture. We are having a tutorial on philosophy of law, and in this audio visual, we're talking about Penumbra cases and the rule of law and its applicability in Nigeria. Okay, so starting from court cases. Penumbra court cases are those cases where the judge, have to make judgments based on uh, what is not explicitly stated in the law or constitution rather, but from interpretations. Okay, so in a case where there is a court case where a judgment has to be passed, but the situation that led to that court case is not in the constitution. Okay, it's not stated that, okay, for example, a case where a student is not meant to uh, let's say argue with a lecturer, for example. Okay, so if that part is not explicitly stated in the constitution, the judge has to give a judgment based on an interpretation, his own interpretation, okay, or an interpretation that has to do in line with serving the interest, okay. So these are cases of penumbra court cases, okay. So now, having said that, penumbra case arise from situation where there is no clear provision in the law to make certain judgments. The courts use their own interpretation to recognize certain rights. Okay, so now let's take a look at two examples of penumbra cases. Okay, the first one is Gracewood versus Connecticut in the United States in 1965, and the case was between uh, two individuals and the Connecticut law. Connecticut is an entity in the United States. Okay, so there was a law that banned contraceptives, the use of contraceptives like condom, and so these people, Griswold and the other person, Lee Boxing. Griswold was the head of Planned Parenthood in Planned Parenthood League. He was the head in Connecticut. Like, for example, I am the head of Planned Parenthood in Ojo, Lagos, okay? And then Lee Buxton, the other person, was the medical director of that league, that organization, okay? So, like I said, there is a law that banned contraceptive. And when we say a group that advocate for Planned Parenthood, that is family planning. Okay, so they will be need to use contraceptives to avoid giving birth to a lot of children. Okay, so that is the picture of the case. Okay, so there was a law against the use of contraceptives, okay, by people and even married people. Okay, so but the court, when these people were arrested for the use for promoting it or advising couples to use it, they were arrested. Now the case was taken to court, but the court now had to pass a judgment for their freedom because uh, although there was no provision for the okay, there was a provision against the use of contraceptive. However, there was a provision for the protection of the privacy of individuals, okay. And the use of contraceptive is something that has to do with private uh, couples, okay. So banning people from using something that has to do with their own private life is against their privacy, okay. So that is why the court had to review it, okay, and said that they cannot be responsible for anything that has to do with people who are married and enjoy their privacy, okay. So The courts later released them, stating that although it is not stated in the court to use contraceptive, however, the law has made provision for the protection of the uh, privacy, even those that were written and those that were not written, of individuals. Okay, and the use of contraceptive is in line with the privacy of individuals. Okay, now the second case is Arrow versus Brown, 1993, in the United Kingdom, in the House of Lord. Okay, chamber, in the House of Lord chamber. Okay, yeah, it was a case between some group of men who engaged in pain versus playing and pleasure sex. There's this act where you engage in sexual intercourse in pain and pleasure. There's what people call it. Okay, I don't want to mention those things here. Okay, so these people engaged in this thing. They and they agreed to it. Yes, there was consent. It was consensual. Okay, so the case was deliberated in the House of Lord. Okay, in the House of Lord chamber. Okay, so the House of Lord chamber now stated that the right, a right to personal autonomy and private privacy, although it is not stated, but the law in the law, but it has to be recognized. Okay, so plain and pleasure sex was an offense, actually, but as long as the House of Law deliberated that as long as it does not involve harm and it is consensual and it has to do with their privacy, it has to be respected. Plain and pleasure was wrong, but because it's something that has to do with your privacy, it is consensual, and uh, they are not harming each other. Okay, it is it should be recognized irrespective of other people views that this is immoral or so on, as long as it has to do with their individual freedom and dignity, which is a fundamental aspect of the law. It should be recognized. So those cases were not explicitly stated or clear in the law, but because it's goes in line with the fundamental human rights of those people, okay, and which is an important part of the law. The law has to do what has to recognize and interpret their judgment based on those things. So this is a clear picture of Penumbra cases. So now let's look at the rule of law. As we all know, the rule of law is that principle that everybody is equal before the law. Nobody is above the law. Even the government and the governed, all of them are equal before the law. Okay. Now, the rule of law helps to secure a non-arbitrary form of government and help to prevent the abuse of power. So let's look at the practicability of the rule of law in Nigeria. Okay, starting from the military era. The military, when they first seized power, they seized power on the basis that the rule of law has to be protected. Okay, and uh, all their policies will be based on the rule of law. But reverse was the case when they got to power. An example is a provision in Section 6 of Decree number 1 of the 1966 decree by the military government. This decree forbid any court from questioning the validity of any decree. Okay, so no court can question the validity of any decree, that this decree is wrong or is right. So the by so it explains that the executive actions cannot be questioned because it is the executive of the military that pass decree, so the actions cannot be questioned. Okay, so now let's take a look at it in the civilian rule. In the civilian rule, we will be using the case of the Nole protocol to ascertain the level of the rule of law applicability in Nigeria. Okay, now the term nole protocol mean unwilling to prosecute, and it is used to withdraw cases, okay, to stop charges against an accused party. Okay, so it is used to withdraw cases. Okay, now the knowledge protocol was obtained under the Constitutional Convention of the Great Britain, and it is under this Constitutional Convention of Great Britain that our own constitution, our own legal system rather, was designed. Okay, so the knowledge protocol was initially exercised by the office of the DPP, the Director of Public Prosecution, who was unbiased because he was not a party member, and so he is faithful to the law and not to a certain set of people. Okay, so in the 1960 Constitution, section 97(5), there was a provision for the office of the DPP. Okay, but and so the knowledge was exercised in the right way. But however, in 1963, the office of the DPP was relegated under the office of the Attorney General, and the Attorney General is a party member, right? Is a politician. He can belong to any party, and also the chief of law. So being a politician and the chief of law, so the 1963 constitution made provision, placed the Attorney General above the DPP. Okay, so because of this, we now had cases of the abuse of the nolle prosequi. Okay, because the Attorney General could just withdraw any case against any charged individual. Okay, like in the Second Republic, the nolle prosequi was exercised by the Attorney General against members of the ruling party who were already accused, right? But because he is also a member of that ruling party, he exercised that nolle protocol. It also happened in the Fourth Republic, where nolle was entered against the suspects of the murder of Chief Bola Ige. Okay, so the Attorney General in Oyo State entered a nolle against the suspect. That is, the suspect was now freed and acquitted. Okay, this was a displeasure to the prosecution council of Chief Bola Ige. Okay, and the prosecution council, who was in the person of Chief Akonde, had to withdraw the case. So this is are some cases of where the knowledge has been abused, and so there is no respect to the rule of law that the general, who is supposed to be the custodian of the law, choose to do or to abuse the law. Okay, so now the question is the rule of law effective? Is it practicable in a country like Nigeria? That will be a question for you guys. Thank you so much for listening to. That will be all for this tutorial. Thank you.